Hello, my dear CA Foundation students. Welcome to another writing practice session for CA Foundation Law with me, CA Preeti Agarwal. In this series, we are trying to increase our confidence by recalling the concepts, writing the pointers, framing the answer. This is one query which every CA Foundation student has. Ma'am, we are not able to frame the answers. We don't know what to write, how to write. So by watching these lectures, you will come to know how to find the answer in the question itself. Hint is given in the question itself. What to write in the provisions part, how to conclude the answer, how to decide what is to be written in the answer. So all those queries will be solved in these lectures, but you have to watch all of them. Just watching one lecture will not give you that confidence. When you watch it consistently, you try to apply it, then you will be able to gain confidence. Now, I am referring my CA Foundation Law Compiler. It is a compilation of all the past exam questions, study material, RTP, MTP questions arranged unit-wise. Not just that. If you notice, each and every answer is divided into 4 parts: provisions, facts, analysis, and conclusion. In the provisions part, you will mention the theory, section number, name of case law, if any. Facts, you will mention the facts of the case, the question in brief. In analysis, you will provide solution, and you will finally conclude your answer. You can also divide it into 4 parts. There it was a very small answer, so I have clubbed the analysis and conclusion. But yes, provisions, facts, analysis, and conclusion. So this is how you will divide your answer. All right. So today I have identified a few questions which I feel are very important for exam. You can expect a question from those. Yes, these are unique questions. You should go through them one day before the exam also. So the first question that I'm going to discuss is question 6. Now I would want you to pause the video, read this question, try to frame the answer on your own. Ma'am, how do we do that? I have provided a left column. Use that column. Try to recall the provisions. Okay? Write pointers and then compare your answer with the model answer. I'm sure you will know where you are going wrong, points that should be included. Slowly by practicing this, you will come to know. And I'm telling you, students, all the questions in your exam will be from this book only. So study my compiler well. If you have not finished the entire portion, study only the compiler and you will be able to crack the exam. Yes, will you do that? Okay. So pause the video, read this question, be ready with the answer, and then discuss it with. Done that. All right. So ABC sells its product to some agent, and it is not customary in their business to sell the goods on credit. Mr. Pinto, one of the agents, sold goods to Messrs. Parul. Now, as we read the question, try to convert that into the solution. So, ABC is the principal. Okay. They have, through some agents, sold the goods. Okay, this is third party. It is not the custom. It's not customary in their business to sell the goods on credit. Now wait. The first thing that you should do is try to recall the section number. Yes. If your answer is section 211, this is the correct answer. Then try to recall what is the title of this particular section. What is the title? Title is duty to conduct the business of agency according to the instructions or directions of the principal. So that will be that title will actually be the first sentence of your answer. As per section 211 of which act? Of the Indian Contract Act 1872. As per section 211, it is the duty of the agent to conduct the business as per the directions or instructions of the principal. Now, what if the principal has given the direction? Then you need to follow the directions. or instruction. But what if there are no directions, there are no instructions given? No instructions have been given to the agent as to how he is supposed to perform his business, to perform his duties. Then law says, if no directions are given, then follow trade customs. Okay, so as per this section, an agent is bound to conduct the business according to the direction or instructions of the principal. If no directions are given in absence, according to the customs which prevail or prevalent, then the agent acts otherwise. Yes, we will write that also. So this you have written. What if the agent acts otherwise? Then the agent shall be liable for loss to the principal. And what if he makes profit? That is also possible. The profit shall be returned to the principal. See, the goods do not belong to agent. So he cannot retain the profit with himself. He is not the owner of the goods. If there is a loss, agent will be liable for loss. If there is some profit due to this, then profit will be returned to the principal. That profit belongs to the principal. So when the agent acts otherwise, if there is any loss, then he will make it good to the principal. And if there is any profit, then he must account for it. He must return it to the principal. We have covered all the points. And see how I made small charts to revise and recall the concept. This is how you will also study each and every question. In the exam, you just need to convert this into sentence form. Okay. Now, in this case, what happened? Mr. Pinto is one of the agents. They sold goods to Mr. Parul on credit, and that third person was insolvent. Now the principal is suing the agent for compensation. Will the principal succeed? Yes, the principal will succeed. Reason? Because, yes, we agree, if the instructions are not given, then you need to follow the trade customs which are prevalent. So here the trade customs, they clearly state that it is not customary to sell the goods on credit. If you do, you will be liable for any loss caused to the principal. So you will write the facts in your own words. Pinto, one of the agents, sold goods on credit to Messrs. Parul, who was already insolvent. Now, many students over here tell me, ma'am, can we also write section 212? Because here the agent is negligent. Yes, you can also quote section 212. But you have to compulsorily write 211. Don't forget that, okay? So you have not exercised your skill and diligence. You can write that also. Because here it was the third party was insolvent. We didn't even check that. See, section 211, it does not allow me to sell goods on credit. I applied that. But can I apply 212? Yes, you can apply that also. Now, students, this kind of explanation or, that clarity, all your doubts will be solved. So I have a question answer discussion along with the compiler, wherein I have discussed each and every question of the compiler. So such kind of doubts will be solved when we go through the compiler question discussion. So all that is available on my website, capreetyagarwal.com. So in case you wish to buy the compiler along with the discussion, everything is available. All these various combos are available. You can purchase it from my website. Please don't ask for free things. I have worked very hard in preparing all this, the format, etc. So please don't ask me whether everything is available for free. I also put in a lot of effort in this, so that is the price which I'm charging for effort. I don't give things for free because I trust my quality. Please don't ask me for free material. Mr. Pinto must make good the loss to ABC. That is my conclusion. Ma'am, how did you arrive at this conclusion? See over here. Will ABC succeed in its claim? This question has been asked in the end. See, normally they will ask you such question in the end. This you need to answer in conclusion. Okay, this is to be answered in conclusion. The next question which I have identified is question 7. Please pause the video, read it on your own, be ready with the pointers. Now, I hope you understood how the pointers are to be framed. Okay. Now, Azhar consigned electronic goods for sale to Aziz. He employed Rahim, a reputed engineer. Now, we had asked the agent to do this. Agent identified someone else, someone who is better suited. Okay. So, this person is known as substituted agent. Ma'am, isn't he our sub-agent? Now, how to identify whether he is sub-agent or substituted agent? See, in case of sub-agent, you are capable of performing that task, but you still identify and delegate it to someone else. But in substituted agent, the original agent is not capable of performing that task. That is why he identifies and he delegates that authority to some other person. That other person is my substituted agent. So here he said that he's an optioner and he will sell the goods. He's of reputation. So he consigned the goods. He authorized Rahim to receive the sales proceeds and settle it once in 45 days. But Rahim sold the goods on for 2 lakhs. But before transferring the proceeds, he became insolvent. You have to assess the liability of Aziz according to the provisions of the Indian Contract Act. Now, this is to be answered in the conclusion part. Now, this entire answer is based on section 195, which talks about substituted agent. Okay. Now, you have to write who is a substituted agent. Actually, section 194 also talks about substituted agent. Section 195 is very specific. It talks that the substituted agent has to be very careful while identifying. It says that the original agent has to be very careful while identifying a substituted agent. So, section 194 actually defines a substituted agent. You can write this also. You can write who is a substituted agent, why he is appointed. Then section 195, it talks about that the original agent has to be very careful while appointing a substituted agent because the principal doesn't know him. The original agent identifies, okay, the original agent identifies that substituted agent. So he has to be very careful while identifying it. So here he identified a person who is of reputation. So I don't think it's the fault of the original agent. So what will you write in section, in the provisions part, what will you write? Yes, you will explain what is a substituted agent. So while identifying or selecting a substituted agent, you have to exercise the same amount of discretion as a man of ordinary prudence. If you do that, you will not be responsible in case any loss is suffered by the principal. But what if the original agent is negligent? He appointed an auctioneer who was already insolvent at this time. So in that case, the original agent will be liable for the principal. Ma'am, just one doubt over here. What if the substituted agent was properly appointed? Who will be liable with the third party? In case of substituted agent, the principal will be liable to the third party because he is properly appointed agent. So yes, the principal is liable for a properly appointed substituted agent. While selecting, he is bound to exercise the same amount of diligence. Otherwise, he will be liable for the negligence, for the acts of substituted agent. It's just a repetition of the point. So here we appointed a person of reputation. We never doubted that, he will default. So in this case, can we blame the original agent? He is not liable. Then who will be liable for acts of the substituted agent? The principal will be liable. Okay. The original agent is not responsible to the principal for the proceeds of the auction. The original agent is not liable because he appointed a substituted agent who was an agent of reputation. So here the original agent exercised due skill, diligence. Okay. He exercised the same amount of diligence as a man of ordinary prudence. So now he will not be responsible for acts or negligence of the substituted agent. These are the key words. You have to write this in the exam. Then I have identified question 9. Please pause the video, read this question on your own. I hope you're ready with the answer. Now, Bhupendra, he borrowed 3 lakhs from Atul. He appointed Atul as and he authorized him to sell the land, and whatever was due, he will keep that and return the balance. Now, he borrowed. It means there is creation of interest. In order to protect this interest, there is creation of agency. Now, what happens over here? Bhupendra had borrowed some money. He is not able to repay it. So, he asks Atul to sell the land. Whatever is due, Atul will keep it and return the balance to Bhupendra. Now, why have we appointed Atul as our agent? Because we were not able to repay that money. Now, law says because the agency was created to protect this interest, the agency is coupled with interest. It cannot be revoked. Please note, students, in case of agency coupled with interest means we have created the agency to protect the interest of the agent. There are 2 steps to be followed. Step number 1, creation of interest. It means I had to pay some money. Because I was not able to pay the money, step 2, I made that person as my agent and I told him that you sell the goods, keep whatever was due to you, return the balance. Creation of agent. Only when these steps are followed, the agency is said to be coupled with interest, and this is irrevocable agent. Section 20. Okay. The agency is said to be coupled with interest where the agent himself has some interest in the property. Okay, agent has himself some interest in the property. Then the agency cannot be revoked. So in this case, yes, there was creation of interest, step number 1, and then there was creation of agency. This makes the agency irrevocable. Now, what was the question asked? Whether the revocation is lawful. So you will say that the revocation is not lawful. See how I have answered that question here. The revocation is not lawful. So whatever is asked in the last part, that needs to be answered. So here, the interest was created and the agency is now not revocable. Then I have identified question 12. So pause the video and read this. Done. This is basically a theory question. Now, why have I highlighted this? Because I feel many students ignore this. They don't study these provisions and it was asked in the exam. Please highlight as expected in the exam. Akash is a famous manufacturer of leather goods. He appoints Prashant as his agent. Prashant is entrusted with the work of recovering the money. Now, he is to be paid a monthly remuneration of 15,000. Prashant during a particular month recovered 40,000 from the retailers and he gives back 25,000. Now, what happened? He recovered 40,000. He retained his remuneration of 50,000. He retained the remuneration and he gave him only 25,000. This was given back to the principal. Can he do that? Yes. So, retention, right to retain, section 217, please highlight this as important for exam. So, you can retain whatever sums you have received. So, what can you retain? For all the expenses that I have incurred for agency, I can retain my remuneration. I can retain whatever sum is due like advance. I paid some advance for the principal to the supplier to hold the machinery. I told the supplier, please don't give this machinery to someone else. I'm giving you 5,000 rupees. I gave you an advance. So whenever I receive some money for the principal, like I receive 40,000 over here, from that money, I can retain whatever expenses I have incurred, whatever remuneration or advances that I have given for the principal. And I will repay him only the balance. So he can retain out of the sums received the remuneration payable to him. It's a theory question, but I wanted to highlight this. I wanted to learn this and go for the exam. The next question which I have identified is question 14. It's actually a very simple question, but the framing is very complicated. Read it. Pause the video, read it. Now, Mr. Yadav, okay, he chartered a vessel. It got stranded. The managing agent, they signed a salvage agreement for Mr. Yadav. The goods, that is wheat, they were perishable. So, the salvors intimated the whole incident to the cargo. They said that it is not possible for the ship to move further. Mr. Yadav refused to reimburse the salvor, as it is the ship owner, being the bailee, who was liable to reimburse the salvor until the contract remained unterminated. Do you acknowledge or decline the act of salvor as an agent of necessity for Mr. Yadav? It seems very complicated, but it's actually very simple. Mr. Yadav is the principal. He is the owner of the cargo. The goods belong to him. He chartered a vessel. It got stranded. The managing agents, they signed a salvage agreement that the goods may be damaged. You try to recover. The ship is stranded over here. It is now can't move further. So you remove everything and take it to the shore. The goods, the salvors intimated to the cargo owner, Mr. Yadav, that see, the goods are perishable. They will be destroyed if we don't, do something about it. He said, no. The ship owner, the goods belong to me, but the ship owner will bear those expenses. So do you think that the ship owners will do it? Or are the salvors the agent of Mr. Yadav? They're trying to save his goods. They are trying to save his goods. This is agency in case of necessity, emergency. Section 189, acts of agent done in an emergency. Now see over here, there are three parties. One is the ship owner. Other is Mr. Yadav, who has given his goods to the ship owner for transportation. And then there is the salvor, who is trying to save his goods, salvage his goods. Now Mr. Yadav is saying, salvor, although they were my goods, but you recovered those expenses from the ship owner. We say nothing doing. The salvor is acting as the agent of Mr. Yadav. They are trying to save. See, are the salvors trying to save the ship? No, they're trying to save the goods. So he's the agent of Mr. Yadav. He is agent by necessity. Now you have to write agency by necessity. You are trying to protect the principal from the loss as a man of ordinary prudence under similar circumstances. So yes, you are able to recover. This is agency by necessity. The salvor had an implied authority. They acted as agent of necessity. Cargo owners were duty bound towards the salvor. Cargo owner is Mr. Yadav. Now I am highlighting the key words for you, key sentences. This should be mentioned in your answer. Implied authority and yes. So you can claim reimbursement for whatever expenses you have incurred to safeguard the goods, to preserve the goods. Okay. So a person can claim reimbursement for expenses incurred to preserve the goods or to save the goods. You can write this in your own. So please highlight this as a unique question. Next, that I have identified the last question of the day, that is question 15. Many students have a doubt in this. Read the question on your own. A rented his house to B on a lease for 3 years. the lease agreement is terminable on 3 months notice. It means that if you want to terminate the lease, you have to give the other party 3 months notice. So either A will give 3 months notice to B or B will give 3 months notice to A, depending on who is terminating. So any party that wants to terminate, they will have to give 3 months notice. Now C is the son of A. C is the son of A. They are in need of separate house to live. So they served a notice to B without any authority. Now A is requesting his father to ratify the action. Is this ratification valid? See, we had studied in Essentials that ratification should not cause loss to the other party. Here, if it is ratified, if the act of C is ratified by A, this will lead to termination of B's lease. B will suffer loss. His lease will be terminated. As per section 200, the act done by one person on behalf of another without any person's authority, if it has the effect of damaging or terminating the right of the third party, it means it is causing loss to the third party, then the ratification is not valid. You can write it in your own words. Any ratification which causes loss to the other party, here the loss is that B's lease will come to an end, then this ratification is not valid. Here the ratification has affected the interest of B, the ratification will not apply. What was asked? Examine whether it will be valid for A to ratify, so that will be answered in conclusion. It is not valid for A to ratify the action of B because it is causing loss to. So please go through this question one day before the exam. And with this, we come to an end of today's session. In my next session, I will discuss the most important questions from Partnership Act. So continue watching these series, subscribe to my channel, and also visit my website capreetyagarwal.com for books, lectures, test series, and podcast revision lectures.